going to, unless there's an objection, we're going to take one of these bills out of order for hearing only, no action today. And that's HB 941. Chairman Golick, you ready?
Yes.
Come on up.
Mr. Chairman, members of the committee, thank you very much for the opportunity to speak to House Bill 941. The chair told me to be brief, and so I'm going to do my best to do that. The crux of the bill, Mr. Chairman and members of the committee, is the following. Right now, under current Georgia law, when a police officer is potentially accused of wrongdoing and is the subject of a grand jury investigation, that police officer can be in the grand jury room the entire time the grand jury is considering evidence, hearing testimony, can hear and see all the testimony, all the evidence the entire time, can come up at the end of the grand jury's proceedings, give a statement, and that statement can be anything that he or she wants to say. I'll just use he. And then cannot be questioned by members of the grand jury or by the prosecutor. That is current law. So what you have is a situation where the police officer can hear testimony, see evidence, documents, and everything that's presented, understand where the grand jury is, and then potentially, and this is a key word, potentially tailor his testimony, which he can give at the very end, and which is not subject to cross-examination. What that does, obviously, when you can hear and see everything in the process, is it allows for the potential of the manipulation of the grand jury process. Some will say that that does occur, some will say that that doesn't occur. The truth of the matter is, I think the main impetus for this bill was to make sure that the integrity of the grand jury process, what happens in that room and how it happens, is above question. And that's why I brought the bill. The crux of the bill will change the current law, as I've just described it, to the following. The police officer will still have the right, to appear in front of the grand jury. However, he will not be able to be in the grand jury room the entire time, hear all of the other testimony, see all of the other evidence that is presented. He will be able to exercise the right to appear in front of the grand jury at the end, and then be subject to cross-examination by the prosecutor and by the members of the grand jury, like any other witness. So he'll give his statement at the end, be subject to cross-examination like any other witness, and then he will leave. And in so doing, I think, we have struck a balance. I'm sure there's a school of thought that says, well, the police officer ought not have that opportunity at all, ought not have the right at all to do that. We have not gone down that road because I think there's a prevailing view that the police officer should have the right to tell his side of the story. What happened, what he saw, what he felt, the details, what he was feeling, what he wasn't thinking, what he was thinking about, what he wasn't thinking about. But we also want to make sure that what happens in the grand jury room is above question. And so the bill, I think, strikes that particular important balance. The police officer retains the right to be in the grand jury room, but if he is going to exercise that right, then he is subject to questioning like any other witness, and then he leaves.
Did you say he stays the entire proceeding?
No, sir. He will not. He will come at the end, and that's part of the bill. He will come at the end to give his statement, and then he's subject to cross-examination like any other witness. And again, the feeling was that a police officer, these aren't my words, but unless you've walked even a quarter mile in those shoes, you just don't know what they go through, the decisions they have to make, the environment that they work in. So the grand jury needs to be able to hear his story if he wants to tell his story. And he's absolutely under no duty to do that if he doesn't want to. But if he is going to exercise that right, then he's going to be subject to cross-examination like any other witness. And I think in that approach, we've struck that balance. That really is the crux of the bill, Mr. Chairman. There are a couple other sections that are important, but that really is the crux of the bill.
See, you have Mr. Spahos sitting next to you. Do you want to present?
Mr. Chairman, I'll just say this because I know time is limited. This bill comes after a great deal of work from all interested parties that had input, with an acknowledgement of the fact that we've got a system unique to Georgia and that certain aspects of it need to change. This bill has tried to balance the state's interest of the officer, and to bring transparency and accountability to that process. This creates records for processes that don't exist now. This creates a clear civil authority to inquire into these cases that's not clear now, and tries to uniform the process throughout the state and make it transparent so everybody can understand what took place. I sit with the chairman to answer specific questions about any provision in the bill.
Mr. Chairman, I failed to make it clear, Mr. Spahos did mention it just now, that the approach that I just described a while ago about what actually happens in the mechanics of the police officer being in the grand jury room the whole time. Georgia is the only state in the country, that has that particular approach. We are a unique outlier. Just because we're the only one doesn't mean that we're necessarily doing something wrong, but it did warrant, I think you'd agree, a closer look as to what we were doing, how we were doing it, and why we were doing it, and then we came up with, I think, this measured approach as to how these situations will be handled.
All right, I think we do have some questions. Senator Ford, do you wish to ask a question?
Yes. Thank you, Mr. Chair. I'm looking at page 6, lines 193 to 196. It reads that the officer may refuse to answer any questions or produce records, documents, and other physical evidence if a truthful answer to the question or producing such records, documents, or other physical evidence would tend to incriminate the officer or would tend to bring infamy, disgrace, or public contempt upon the officer. Now, that officer's refusal to give testimony is unique. I mean, if a citizen, and you tell me if I'm wrong, if a citizen goes before the grand jury, they have to answer the questions. Is that correct?
Of course, an individual can always invoke their Fifth Amendment right.
Sure.
If they're in the grand jury. So in this situation where you have the police officer go ahead and give a statement, if at the very end he did not subject himself to cross-examination and invoke his Fifth Amendment right, the prosecutor would still have the ability to call rebuttal witnesses to refute potentially his statement. And that's one of the protections for the integrity of the process that we've built in. As far as the language goes about attempts to bring infamy and so forth, that's current code. That's actually language that's used in other places in the code that Mr. Spahos can probably speak to more specifically. But it all relates back to the fact that he, like any other defendant in front of the grand jury or individual in front of the grand jury, can always invoke his Fifth Amendment rights.
The Fifth Amendment rights, fine. But this issue of an officer, I mean, there's some, like me, who don't believe the officer should be in there at the beginning, the duration, or even at the end. But for an officer to refuse, he has the right to invoke his Fifth Amendment right. But to say that, in effect, he can refuse for other reasons, that's problematic as far as I'm concerned. If the officer is going to have the benefit of being able to testify before the grand jury, ought not that officer be subject to cross-examination? And and I don't think he should be able to determine, aside from the Fifth Amendment invocation, whether or not he's going to be subject to, I mean, that's very subjective. And
Let me stop here. I'm trying to move it along. Can Mr. Spahos or Ms. Travis point us to where this might already be in the code?
That's what I was going to do, is realize that this is the warning that gets given to the officer if he chooses to testify. So that's what starts at 186 and 187, and this list of 1 through 5 or statements of current law that we are advising the officer of. So in Georgia, we've got the Fifth Amendment, like everybody does, and then we've got a statutory provision about self-incrimination, and so this is a statement of current law. This actually applies to any witness that would testify in any proceeding. They can choose not to testify and state this as a reason. Or under the Fifth Amendment of the Constitution, you cannot state any reason and just refuse to testify, and I can't compel you to do it. So this is just a statement of law.
Let me follow up.
But
But you're,
wait a minute. We need, if we can, to clarify where in the code these,
I think it's in Title 24, but I'll have to pull it out.
Yeah, I don't know off the top of my head.
all right, that,
Well,
yeah.
I'll put somebody on that right now. So I got somebody looking for that right now.
but the ability of the officer to appear before the grand jury and to sit in that grand jury, whether is unique to Georgia, is that correct?
Correct. The ability of the officer right now to be in the grand jury from the very beginning, hear and see everything, and then make their statement at the end, and then not be subject to cross-examination, all under current law, that is unique to Georgia and the nation.
Okay. And that officer being under your bill, being there at the end of the process, and being able to refuse, not just for Fifth Amendment rights, but for other rights, you're saying that's not unique? Or is it?
Well, of course, the ability to invoke the Fifth Amendment right, that's really what it comes down to. If he or she doesn't want to go, is not going to testify, of course, the grand jury is going to hear and see that. That is going to send a particular message to them. But an even stronger reaction to that, candidly, is going to be the fact that the prosecutor can call rebuttal witnesses to refute, potentially, what the officer has said just, a few minutes ago, and then refuses to answer questions. So it all paints a picture for the grand jury in a particular way, and they're going to express their opinion at the appropriate time. As far as the language goes about bringing disgrace, infamy, and so forth, that's a term I'll call, that's used in other areas of the code.
We may
It's not
have an
unique.
answer.
Oh, we will go ahead and get
But
it.
it's new to this.
Go ahead, Mr. Fayhoff.
It's new to this in that we've created the warning that we're giving to the officer before he testifies. The right under that is not new. I cite you 24-5-505, party or witness's privilege. No party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness or any member of such party or witness's family. We actually carried that over when we created the new evidence code. We carried that over from old evidence codes. It's been in, that's the Georgia statutory right not to testify, and that applies to
In
any
any
witness.
proceeding.
It applies to any proceeding and any witness. So all this is a statement to the officer, if you're gonna testify, these are the rules.
All right, thank you. Senator Liggins?
Thank you, Mr. Chairman. I know that there are some people that are, and others that are concerned about the fact that the bill doesn't provide for a special prosecutor if you have a situation where there's been a death caused by an officer rightfully or wrongfully. Has any consideration been given to that, or are you open to an amendment that would allow for that?
I really appreciate the question, Senator, and it's something that I have personally struggled with, and there are very good arguments on both sides. On the one hand, when you have a fatality, and I'll just limit it to a fatality. If you have a fatality, the thinking is that, well, because of the relationship potentially between the DA and the police, locally, that is obviously a very close, constructive working relationship over the course of many years in a lot of jurisdictions, and so it's a very close relationship. And so there's an argument to be made for sure that when you have something like that, you want to have as a matter of law that DA will go ahead and recede from taking on the case, and a special prosecutor will go ahead and be appointed to take over, given the sensitive nature of what we're talking about. On the other hand, there's the fact that you're talking about these DAs who are elected in the 49 circuits by the people, and they are elected very arguably to exercise their discretion on the tough calls. It's easy to make the easy calls, but it's on the tough calls that they are elected by the people as constitutional officers to make. And their argument is going to be, and I think it's a good one, that, look, we're elected to make these calls. If you go ahead and mandate a special prosecutor, aren't you presuming that the prosecutor will not be able to do the right thing? To me, that has resonance. I believe in local control. People elect their DAs and they can unelect their DAs. But I don't, Senator, I don't dismiss in any way, shape, or form the validity of the special prosecutor position on
Let
this.
me interject here. If there were to be such an amendment, who would be the appropriate appointing body?
Well, let me start out by saying as probably the only special prosecutor in the room, it becomes a little problematic. That's the question, who's going to do it and how are they going to do it? Let's take, for example, the Prosecuting Attorneys Council. I'm a director appointed by 9 elected district attorneys. I've got 10 assistant prosecutors in my office. We travel all over the state handling actual conflict cases now, where the district attorney is, for some reason or another, related to a party or some aspect of an actual conflict. It's all we can do with the staff we've got now to cover those cases. And we run that out of Maejor, Georgia. So you know how big this state is. Most of you travel from all over. The practical aspect of assigning those cases to one place, be it in my office or the Attorney General's office, is somebody's got to do those cases. The district attorneys can't turn around and start doing them for each other in the circuits. That's kind of how I got to where I'm at, because they're doing all they can do to handle their cases. The DA's position also is that this is part of what they're elected to do. If there's an actual conflict in one of these cases, which does occasionally occur, then my office or another district attorney's office can handle it. But to do an across-the-board conflict because there was a use of force, we believe that takes it out of the citizens' control of the DA that are across.
How many of these cases are we?
The GBI is doing close to 100 a year now, investigations of these cases. I don't have them in front of me, but I think I've heard anywhere from 80 to 100 cases a year that are being independently investigated by the GBI. And keep that in mind. There is an independent investigative authority in this state that handles almost all of these cases now, including Atlanta. And that's the real check and balance there.
You're
You've got
talking
a state
about the
agency.
GBI?
Yes, sir. The GBI comes in and handles these cases. I've personally been involved with the training process that's going on right now, where the director is training every agent in this state about conducting these investigations and how these could work. So we've got an independent investigative authority. I think that's the check and balance that you're looking for. You don't want law enforcement investigating their own department's use of force. And that's what the check and balance we've had.
All right. Do you want to follow up?
Yes.
Senator Reagan?
Just to follow up as to what you said, there's another consideration as well, and that is that sometimes, whether intentionally or unintentionally, in order to avoid showing a bias towards an officer, perhaps the judgment is clouded the other way, and action is taken against an officer that perhaps an independent prosecutor might not do. And so, there are these pressures that are different, especially when you're involved in a highly charged case, whether it's been a death. And so I really think that we need to look at this very closely and perhaps consider putting something like that in the bill.
I understand your position, Senator, and candidly, the first thing that comes to mind, of course, was the shooting in Brunswick. That's the first thing that comes to mind when you raise that possibility. I can't sit here.
There are other, we look across the nation, there's situations where people wonder, why are we doing this, why are we not doing this?
You would think intuitively that the prosecutor in these cases would just naturally want to step back and allow someone else to come in to take care of it in order to not have even the possibility of the appearance of any sort of impropriety. That's the cleanest, best thing to do.
Correct.
And I understand where you're coming from on that. If I were sitting in your chair, I'd have the same concern. I do recognize, I'd be lying to you if I said I don't recognize, if I didn't recognize the fact that, again, we are talking about independently elected. And the situation, for instance, in Brunswick, is that the prototype example that we see across the state, or is it an outlier? My personal feeling is it was an outlier. It was a terrible outlier, but it's an outlier nonetheless.
I will say this, that we train now with our elected prosecutors. We've got some ethical guidelines. If a prosecutor does believe that they are too close to a particular case or a particular set of circumstances, then they conflict out that case. And we do handle those on an individual basis.
Senator, I just want to be clear, Mr. Chairman, I defer to the will of the committee as it relates to that question. And not all questions on the bill, obviously, but I understand where the senator's coming from, very sensitive.
Let me try to do two things. One, return back to my question of if we have an amendment that look to appoint someone from outside of the circuit to be a prosecutor, who should that appointing authority be, the Attorney General?
Well, certainly the Attorney General is not in the room, so I would be interested in his input on that. I would think he would respond in the same way I did, that it's not possible to do that out of Atlanta and run those cases all over the state.
Well, certainly he could appoint someone from the neighboring
Which is the
circuit.
authority that he's got now when there's a conflict. But to shift these to the fellow DAs or the other DAs, the resources are not there for that. It is very problematic to leave, for a district attorney to leave his circuit, his or her circuit, and go across the state to another circuit to deal with these cases. And quite frankly, these cases are very time consuming, they're very fact specific, they're intense investigations that go into them, and they take a lot of time and resources. So to place them on the other DAs is problematic.
When you mention 80 to 100 cases a year, if you were to look at cases involving serious personal injury or death from the use of deadly force, how many do you think you'd be?
I think that's the number that the director is used.
So that's not just general all disqualifications.
No, sir, these are use of force cases that GBI has been conducting investigations into.
Senator Jones?
Thank you, Mr. Chairman. Just one quick question to follow up. That would be serious bodily injury, 80 to 100. How about just death only? Do you have a figure for that?
I would have to defer to the GBI on that, but I would submit to you that any use of force, particularly firearms or automobiles that result in that serious injury and death, that they all carry the same type of impact to the investigations, or just as intensive whether somebody dies or whether or not they were just shot. So to draw the distinction is begs the problem.
See no further questions, so we'll move on to the public comment period.
Thank you, Mr. Chairman, members of the committee.
Thank you. Stick around. Representative,
Yes, sir.
stick around if
Yes, sir.
you can. We have Gerald Briggs, County Vice President of the NAACP.
Yes.
And we're going to confine public comment to 3 minutes. Plus any questions.
Thank you, Mr. Chairman. Thank all the members for allowing me to speak. This is a very touching subject to the hearts of the people that I represent, both in my capacity as a criminal defense attorney and in my capacity as the Vice President of the NAACP Atlanta chapter, as well as the Chairman of the Georgia NAACP Criminal Justice Committee. And I think that this bill, in some ways, is good, but in other ways, does not go far enough. Over the last several years, we've had a lot of police-involved shootings that have ended in deaths, both in this county, this state, and across the country. And Georgia does need to do something with the way that police officers are allowed to be in the grand jury. I completely disagree with a police officer being able to sit and listen to the entire testimony in the grand jury.
I think the bill doesn't allow that, so.
I know.
Okay, try to stick to what the bill addresses or what you think it should address.
Okay, I'll get right to the point, Chairman. I don't think a police officer has a place to be in any grand jury at all. I would disagree with the provision allowing them to sit and testify at all. No other citizen has that right. I am a criminal defense attorney. I've been such for 11 years. The police officer does not need to be involved in the grand jury process. That's for trial. He has certain trial rights, and that's exactly what we're citing here between 188 and 204. That is a trial right of self-incrimination. to allow a police officer to sit in a grand jury and be questioned and refuse to provide testimony is a trial right. He should not have a place in the grand jury. It should be the citizens making the decision whether or not there's probable cause to proceed with the case, and then at that point, he can defend himself just like any other citizen in Georgia. So I would disagree with this bill, but if the bill does proceed forward, I would like for positions 188 through 204 to be removed, not allowing the police officer to refuse to answer questions. Thank you.
Thank you. Keep your seat. I have a question. Senator Jones? Oh, Ford, sorry.
Let me just be clear, as a layperson, I'm not a lawyer, I'm a layperson. What you are saying is you don't believe that the officer should have the right to testify or to appear before the grand jury, whether it be during the proceedings or at the end of the proceedings.
That is exactly.
And refuse to testify.
Yes, that is exactly
That's a unique right that other citizens don't have, is that what you're saying?
That is exactly correct.
Thank you.
Senator Bethany?
Thank you, Mr. Chairman. Thank you very much.
Sorry.
No, it's fine. I just want to get a clear view of, you said that you oppose the bill, but if it moves forward, you want this section out.
Yes, because there are portions of the bill that aren't good.
Okay. My question to you is, you feel like the bill makes matters worse than the status quo?
I think that it does not still remove all the appearance of impropriety to have a police officer.
I apologize. I'm not asking if it meets all of your desires.
Yes.
I'm saying a world that we live in today versus a world that would be, again, I understand that you want things different in here.
Yes.
But a world governed under this, you would prefer the rules as they stand today, unamended as this.
No, I would not prefer that. What I would prefer is the ability for a police officer to sit in the grand jury at all to be removed.
I'm not arguing with you. What I'm saying is, I heard you say you opposed the bill, and then you opposed a specific provision. My question is, I'm trying to get a feel, because I heard you say there are things that are good in the bill.
Yes.
And I guess what I'm trying to get down to is, the bill, even with the imperfections that you perceive, I thought I understood your testimony to say would be better than the world in which we live today, but maybe I misunderstood.
No, you're correct.
Okay.
But my position is this: I don't want to be backed into a position where it's stated that I agree with everything that's in the bill.
I totally understand. I totally understand that.
Thank you.
Thank you, Mr. Chairman.
All right. Thank you.
Thank you. Thank you.
Next, we have Lance LaRusso.
LaRusso.
And who are you with?
I'm an attorney and I'm the general counsel for the Georgia Fraternal Order of Police.
Go ahead.
Thank you, sir. I've been a certified law enforcement officer since 1989. So in addition to practicing law, I've actually been the officer that's been on the street making these judgment calls that are reviewed by the grand juries. I've actually been a firearms trainer and a deadly force trainer for probably 20 of those years. When this bill came forward, there was a question of, is there a reason, as Representative Golick said, to change the appearance of impropriety by officers being in the grand jury at all times? And there was a recognition that if it's causing consternation, then we need to do something to be more transparent. I was in all of these meetings with all of the stakeholders that were involved, including the prosecutors. And transparency was one of the things that we were focused on. That is why you see all the provisions in the bill for a transcript. Currently, right now, if you want to know what happened in a grand jury after an officer's use of deadly force was reviewed, you can't find out. Under this bill, there will be a transcript kept. It will be released at certain points, and there is an opportunity for the information to be released. Now, I think it's very important to note, why are law enforcement officers being allowed to testify before a grand jury? If you look in the United States, we have about 11 to 12 million arrests made every year. By statistical averages that have been taken by different entities, for every one of those arrests, you have 6 to 10 contacts between law enforcement officers and citizens every year. Yet you have less than 1,000 people throughout the United States where deadly force is used against them. So these cases, while they form a large cause of consternation, and justifiably. They wear a badge of office and they have the government patches on their shoulders. There is a need to review it, and there is a need, more importantly, at the end of that review, for everyone to be able to look at what happened in that grand jury. While there is that need, the law recognizes that the reasonable subjective belief of the officer is paramount to the consideration of probable cause. When you look at 17-4-20B, which is the statute in Georgia that authorizes a law enforcement officer to use force, including deadly force, the statute quotes a reasonable belief that a certain set of situations or circumstances exist that would justify the use of deadly force. It is impossible for a grand jury to consider whether or not the use of force was appropriate unless they hear from the officer. Georgia is not alone in allowing officers to testify in grand juries involving the use of deadly force. The last time that I checked, we were looking at about 11 or 12 states that specifically say they can come in, and many more states where the prosecutor can subpoena them as a witness.
I'm sorry, what was that code section again?
17-4-20 subsection B. Yes, sir. And when we look at this entire process, what we were looking for was down the road, these officers have to testify after using deadly force, and then they have a situation where they could be facing civil suits, they could be facing discipline in their agencies, and even if the officer's cleared right now, there is absolutely no record of why they were cleared. The grand juries are subject to scrutiny, the DAs are being prosecuted, if you will, in the media, and right now people are judging whether the grand jury's decision was correct based on an 8-second average soundbite of what's brought up. When we brought this matter to the Prosecuting Attorney's Council and they brought it to us, we said, what can we do at the end of this process to make sure that people can have faith in it? That's why we had the civil grand jury process. There are cases that are so crystal clear that the officer not only should have used deadly force, but had they not used deadly force, they would have been derelict in their duties.
Try to summarize.
Obviously, there may be questions about the bill. The bill is this subject, and I want to remind you of a lot of work. I think the bill should go forward. The only thing that we would ask is right now there are cases that are building up. We would like an amendment that will allow prosecutors to use this civil process for a 12-month period after it is hopefully signed by the governor. So you have the civil process and the criminal process. But we know that there are cases that DAs are sitting on, and those officers sometimes are waiting 4 years to have a resolution as to whether or not they will be charged or to have the case go forward. So the civil process will allow the DAs to look at those crystal clear cases, have them brought forward, and have some resolution for the public, the prosecutors, and the officers.
When you refer to civil process, are you referring to the disciplinary proceedings?
I'm using it interchangeably, and I apologize. In the bill, there is a civil section. When we're talking about the civil process for the officer, there is discipline that's upheld. I've had officers I've represented who used deadly force. They waited 4 years for any type of a resolution from the grand jury. During that time, even in clear cases, they were not able to apply for other jobs. They were not able to accept other jobs, even though they were ultimately cleared, even in cases that were crystal clear that deadly force was authorized.
And you want to limit to 1 year on the civil?
No, sir. Right now it is limited. But what we're hoping is for an amendment that will say, if it's signed in, let's say July 1 of 2016, that there is a provision that a DA can go back, irrespective of how long that case has been pending, and bring it to that grand jury in that civil format, so these cases can be cleared out. Was I clear? So I may have missed some.
Have you made any effort to craft an amendment?
No, sir, but I can do that. We've talked about it. It's something that came up after Representative Golick was kind enough to talk to us, and it did pass the House.
We're hearing, this is an informative hearing, so if you want to weigh in on that, please provide the committee with something in the next few days.
Yes, sir. I can do that.
We intend to do something on it, hopefully by Monday.
Yes, sir.
Are there any questions? Don't see any, so thank you very much.
Thank you, Mr. Chairman.
The next person is Oliver Hunter, an attorney
Good afternoon, Chairman, thank you all, the committee, and thank you for the opportunity to speak with you today. I'll be very brief. Again, I'm Oliver Hunter, an attorney who has practiced in the area of local government law for over 30 years. I'm here today in the role of a member of the Political Action Committee for Alpha Phi Fraternity Incorporated, the Georgia District. Founded in 1906, Alpha Phi Alpha is the oldest Black Greek letter collegiate fraternity. We count among our members the late Dr. Martin Luther King Jr., Justice Thurgood Marshall, the late Mayor Johnson, and Ambassador Andrew Young. After the Trayvon Martin case, and after the prosecutors in both the Mike Brown and Eric Garner case failed to get an indictment, our members met to discuss tangible strategies to help our youth minimize the negative outcomes when dealing with peace officers. One strategy was the development of a module for our mentees and their parents on how to interact with law enforcement officers.
Let me stop you here. We've got a lot of witnesses, and if you'll
Go straight to your
straight to the bill.
Okay, we essentially support the bill, but we think it does not go quite far enough. We presently have a system that relies upon district attorneys proceeding against individuals, officers, with whom in many instances they may have both a professional and personal relationship. This is not to suggest that in each and every instance there is a genuine conflict of interest, but there is unquestionably the appearance of impropriety in every case. We should not be completely surprised that there is a growing lack of trust for a system that sanctions the use of counsel with an inherent conflict of interest, or at least the appearance of a conflict of interest. In most instances where there is an officer-related shooting or death, the GBI is routinely called in to conduct the investigation. We do that not because the local law enforcement can't conduct a competent investigation. We do that in part because we want to make sure the findings of any investigations are free from the appearance of impropriety or are not self-serving. What good would it be to have a report that no one could reasonably trust? We want to make sure that those who are tasked with the responsibility of conducting investigations are not having lunch with the targets of the investigations. We see not only fairness, but the appearance of fairness from both the investigators and the prosecutors. A representative democracy relies upon its citizens' respect and trust in the administration of justice. I have a tremendous amount of respect and appreciation for the work of our peace officers and the work the DAs do, but this issue is much larger than them. It is about preserving respect for our judicial system. I urge the committee, should there be an amendment, to amend this bill such that a special prosecutor could be appointed when there is a death or serious bodily injury resulting from the actions of a peace officer. And if I may end with a quote from Martin Luther King today, he once said, "We are confronted with the fierce urgency of now. In this unfolding conundrum of life and history, there is such a thing as being too late. There is no time for apathy or complacency. This is a time for vigorous and positive action." Thank you.
Thank you. Next witness is Billy Grogan, of the Georgia Association of Chiefs of Police.
Mr. Chairman, thank you for the opportunity to speak on this important piece of legislation. First off, I'd like to say that the Georgia Association of Chiefs of Police supports this piece of legislation. In Georgia, police officers respond to millions of calls for service, and out of that number, we arrest a few 100,000 people. And out of that number, use of force, it happens to about 1,000 people. The GBI investigates 80 to 100 use of force incidents per year of serious bodily injury, and I think last year there were 20-something people that died during the police use of force. So we support the bill not because we believe that there's an issue, but because of the appearance of impropriety in the process that's already been stated by others. One of the questions that's been raised is, why should police officers get to go to the grand jury? And I'll try to briefly just answer that and answer any questions you may have. Police officers are given the authority and asked by the citizens of the state of Georgia to go out and put their lives on the line every single day. And that's different from most citizens. They're not required to do that. They have to make split-second decisions, and as Mr. LaRusso said earlier, only they can really explain from their perspective about what happened. And so because of this mandate that we have with the police officers, them having to go and put their lives on the line, I think it's an important consideration that they're allowed to be in there to give a sworn statement and answer questions. We certainly agree that the process as it is now should be changed, and we support the current piece of legislation that's been proposed.
Thank you very much. See no questions. Next person signed is Darwin Favorito with Voter Georgia.
Thank you, Mr. Chairman. I've got a one-page handout. I can read.
Yes, please. Did I get your name right?
Yes, that's good enough. Nobody gets it right even me. So thank you, Mr. Chairman. I came here today to ask the members to abide by the Constitution of the State of Georgia and the U.S. Constitution and their oath of office to vote this bill down at any time in this committee. The reason, quite a few reasons, but one of the points that needs to be clarified, and this was clarified, a citizen has no right to appear before a grand jury to be investigated. This is a special unequal protection right in direct violation of the Georgia Constitution. Now, when there's a current right that's on the books that really needs to be taken care of by this bill, it doesn't do that. It's loaded. This bill is loaded with additional double standards that are, and I've listed them for you. I'm not going to go into that for the purpose of time. But the bill was created in reaction to an AJC article that said 171 people have been shot dead, none have been prosecuted. The article on the investigative study found that there were a couple of crimes. One is the prosecutors had a tendency to protect the officers because they work with them. And the second one was the special privileges that we are talking about to testify before the committee. This bill supposedly dials back those special privileges, but in reality, as Senator Fort's already explained, lines 193, 197 give the officers a loophole to avoid cross-examination, and there's no provision in this bill, despite what I just heard, to prevent the officer from attending the entire hearing. There is no provision in this bill. I've read it 2 or 3 times, several others have it as well. Now, if they want to achieve the objectives, if the officers want to achieve the objectives, they can simply modify Section 17752 in a single paragraph. I have it here. That's all it takes to eliminate the special privileges or even dial them back as they're claimed. Just simply need to scratch a few pages. What instead has happened is they have identified and actually have defined an entire redundant grand jury process that is a whole set of series of unequal protections for officers that the citizens of the state of Georgia don't have. And we would like equal protection for all people in accordance with the Constitution of the state of Georgia. That's your duty to enforce. In the case, the most important thing I can tell you about this bill, in addition to what you've already heard, it legally subordinates the grand jury to a district attorney. Everything they get and request goes through the district attorney. Right now, that process is entirely independent. The district attorney, people can petition for an indictment if they want to. They have that right. That right will be taken away as a result of this bill. Now, if there's any question about whether or not a district attorney can be unbiased, I would like to refer you to the case where we sit right here in this county, and a lady named Amy Bernucci, who I'm quite familiar with, police in Alpharetta.
Start summarizing.
This is my summary. Police in Alpharetta broke into her house when she was sleeping, shot her 3 times in her bedroom after she called 911 to get her to get them out of the house. The DA in this county charged her, even though she harmed no one, charged her. She sat in jail for 8 months without a trial and hearing until she pleaded guilty to charges that she was innocent of, and that way that destroyed her civil suit, and she is now destitute. Her life is destroyed, and she's never even been physically accused of harming anybody in the state of Georgia. So that's what you're dealing with if you're going to subordinate the grand jury process to a district attorney. And I thank you for the time, and I hope
You
you,
have a question?
I'll be glad to answer.
In the report?
Yeah, just for clarification, the latest figures I have is that there are 185 deaths over 6 years from 2010, 2015,
Yes, sir.
without an indictment or charges brought.
You're right.
But the question I have, and if you can't answer, Mr. Figueroa, maybe legal counsel can, we have heard testimony that the officer's appearance before the grand jury is unique to Georgia. Then we've heard some other testimony that there are 11 or 12 other states that allow for it. I'm confused if Ms. Travis can clarify that for me. I'd appreciate it if Mr. Figueroa can.
Well, my understanding, and I think Representative Chappelle has also said the same thing, that this is a unique situation only in Georgia. Only in Georgia can an officer testify before a grand jury and also be present for the entire hearing. No other citizen has that right. That's unequal protection by any stretch of the imagination. You cannot vote for that and uphold your oath of office.
Thank you very much. Next witness is Cleo Raiders.
Good afternoon, and thank you all for allowing me to come and speak. I've sat in the back there, and I've listened to everything everyone had to say. My name is Frida Williams. My son was murdered in Union City back in 2011, December the 14th. He was unarmed, had nothing to do with why the officer was out in Union City, called out there that day. But the officer, Luther Lewis, shot my son in the back twice. My son is gone, he's dead. I am here because, give me a few minutes. I went through 2 grand juries. The first grand jury, Luther Lewis sat in the whole session, listened to everything, and was able to, at the end of the session, give a rebuttal and say whatever it is he had to say. I waited 3 years. I got the depositions, read over all depositions. My son's case went to Paul Howard on Fulton County, went through his office. All of that information, the same information that they did not indict on, is what I read. After 3 years, I bought my son's case back with that same information that Paul Howard's office had. Through AJC and through the news, WSB, they took all that information, which was proof that Paul Howard's office did not do their job in the first place. After they bought my case back, thank God for Channel 2 News and AJC, they bought my son's case back. Paul Howard reopened my son's case. Now, when he reopened my son's case, when you talk about double jeopardy, double standards for the police officer, when he reopened my son's case, the evidence was found that the chief of police, which was in Union City, Chief of Police Odom, covered and admitted to officers that he covered for Luther Lewis, stated to the officers that Luther Lewis should have went to jail, but he covered for him, and that's why he's out now. Paul Howard's office took my son's case back to the grand jury. They listened, they had evidence, all these officers, they had not only that, the chief of police It had, he had records, Paul Howard's office had, that showed proof that there was so many incidents that had happened with Luther Lewis that was not even in the files. With all of that evidence not being there, this is the second time my son's case went before the grand jury. They still found my son's case. They did a no bill again. Paul Howard's office, they have all the information. The officer admitted. Everybody know. So when someone said here when you first started and talked about the DA's office, this DA's office should not have been able to take my son's case back to a grand jury when they didn't do their job in the first place.
You would kind of summarize past the time.
I'm sorry.
That's all.
I feel the whole bill should be stricken down. It does not work for the citizens at all. When you have not only just my son, the bottom line is you had Channel 2 did the story, 185 people for over 5 years. There's been no indictments of any officers in this state. So I would like to ask any of you, how can I or anyone else get justice in a system where the case go before a grand jury twice with all the evidence that show you that the officer is guilty, and the officer get to sit twice and listen to all the evidence and cry at the end of the session, and they let him go?
Thank you. The next person signed up to speak is Erica Williams, from Georgia Voting.
Hello and good afternoon. Thank you for allowing me to speak. I don't want to repeat myself or waste any more time. Clearly, I don't want you guys to pass the bill. I've spoken to a couple people on reasons why. A lot of them have already been spoken. But what I do want to ask is that if you go ahead and pass it, that you add in an amendment that it makes it mandatory for court reporters to be in the proceeding right now on 102. Section 3, line 102, it states that upon the request of the district attorney or peace officer, then the court reporter will be there. Maybe the district attorney will ask for it to be, maybe it won't, so it still gives them leeway to have someone there. And if the state is just gonna keep on letting this civil thing go and protecting officers and paying millions of dollars when they go to civil suits, then at least allow people to have a record of what happened in the grand jury available and filed.
Thank you very much.
Thank you.
The next person is Ted Metz, the Georgia Voter.
Good afternoon. My name is Ted Metz, and I am actually here because Judge Paul Nally could not be here. He asked me to read a statement for him. And it's kind of lengthy. Short. I'm sorry?
Paul Nally.
Paul Nally from Pine Log, Georgia.
And what
district?
What
He's
court?
retired. I gave everyone a packet, so you have that information in the packet. I didn't bring that piece of paper up with me that has Paul Nally's, only to get Paul Nally's. That just says Pine Log, Georgia.
All right. Go ahead.
So, Mr. Nally wants you to understand that there are 4 systems of courts in the state: the Article 5 Judicial Court, Article 4 Administrative Court, Article 2 Legislative Court, and the Article 1 Courts of Inquiry. Now, the grand jury of each of the county of the state is independent Article 1 Court of Inquiry. and by the grace of Almighty God, the grand jury, the criminal trial jury, possess constitutionally recognized power not allowed to any other branch of our government, the power to be the sole judges of the law before them. It is they who administer accountability upon the very letter of the law, and all public officers and employees of the state, right along with the rest of its peons. No one is immune from and shall stand equally before the gaze of that court and its administration of the criminal laws. The continued effort of our legislators is to throttle the free and unrestricted use of the court of our liberties, and is exemplified by the fact that throughout the verbiage of this House bill, the term district attorney is used. This is instead of the generic term prosecutor, and is unabashed attempt to make the reader of the law, the reader of the rules of the practice of the procedure, believe that only an elected district attorney or one appointed by the Attorney General has the sole authority of the law to present the case of police use of excessive or deadly force to a grand jury. Further, that such presentation be made within 1 year. That is found in the proposed language in 15-12-771B, Section 1. That one paragraph turns this proposed legislation into an instrument of legislative plunder and of the rights of the power of the grand jury and the citizens' First Amendment rights. And he goes on, but you can read that for yourselves later. In short, Article 1 of the Constitution, of the Georgia Constitution, permits you only to enact general laws relative to grand jury upon only two issues: their selection and their compensation. There is no constitutional authority for you to instruct a grand jury when a court of inquiry is assembled by general statutes to engage in this hearing form any particular class of citizens or public officer. Neither is it within your legislative discretion to provide by general law for any oversight by district attorneys. District attorneys, like Superior Court judges and all legislators, serve the lawful ends of the grand juries, not the other way around. And he does go on a little bit further, and he does apologize that he could not be here in person, but he had a death in the family. He's conducting a memorial service for his father.
Thank you. He's retired Superior Court
He's
judge.
a retired magistrate judge.
Thank you very much.
You're welcome. Thank you for having me.
Sir Maejor? I'm sorry, can you state your name?
My name is Sir Maejor. I'm the president of the Greater Atlanta chapter of Black Lives Matter. I'm the nephew of the Honorable Justice Alan Page. I'm here as a spokesperson for the people. I've heard the chief or the representatives from the chiefs associations and these other law enforcement agencies, and they said they came together collectively with these parties to produce this bill. Yet I have not heard them say that they reached out to the community-based leaders, clergymen, or these our civil rights organizations to try to pass this bill together. If you turn on Fox News at any given time, you hear the Bill O'Reilly is great for saying this, the war on cops. You create this war on cops narrative, and what you do is you set law enforcement higher than the citizens that they're sworn to protect and serve. The blue line, the thin blue line that we have representatives from law enforcement that know this is to be true, is that the thin blue line has this narrative, them versus us, okay? And so when you say that we are all created equal, or that we are all citizens, you then have a double standard, because law enforcement are treated with special privileges that an ordinary citizen like myself or you guys can't have that protection. And so I'm totally against the bill. I think there were some good things in the bill that was, better, but I think that I'm against the bill. I think that law enforcement should not get special privileges that an ordinary citizen wouldn't be able to have. And as I wrap up, I'm also a certified security guard and a certified fugitive recovery agent, which is equivalent, the same thing as a bounty hunter. And if a bounty hunter, as private citizens, can't have that same protection that these officers are requesting, that's a double standard because they do very similar jobs. And they are faced with the same dangers, credible threats, where myself, I was put in a situation where I thought that I had to take someone's life. But because this person didn't have a weapon, I thought he had a weapon, he made me believe that he had a weapon. Had I shot and killed this guy, I'll be writing letters to you guys from the county jail or from state prison. So I'm against the legislation or this bill that's being presented. And I said you strike it down and come back to the drawing board with everyone, all the stakeholders, not just law enforcement.
Do we have a question, Senator Bethel?
Thank you, Mr. Chairman. Thank you, Mr. Major.
Yes, sir.
Question, and I get that you don't like the ability of a law enforcement officer to testify, or have an absolute right to testify. But if I'm understanding you correctly, today's world, they sit through the entire proceedings and can give a statement without any response or cross-examination. And if I understand you saying you're against the bill, you're saying you prefer that world to a world in which all they can do is come in and testify. That world is better.
Thank you for your question. What I propose is that if they are going to go through with the process, and if they're going to waive their rights, and want to, not waive their rights, but if they want to go ahead and speak, then they should be subject to being cross-examined if that's going to be the route that they want to go. It shouldn't be, well, I'm going to go halfway through the process, and then I'm going to opt out from being able to speak or be able to answer questions.
Senator Ford?
Isn't it true that the only change that this makes is that the officer will not be able to sit in the entire hearing? He will be able to come in at the end, will be able to make a statement, and at his discretion will not be subject to any cross-examination. Isn't that the only change that this makes?
That's what I'm getting.
And isn't it true that District Attorney Paul Howard, in the Luther Lewis case that Ms. Waiters talked about, isn't it true that the District Attorney Paul Howard, Fulton County, said that he believed Luther Lewis would have been indicted if, in fact, Luther Lewis did not have an opportunity to give testimony in that case, that he would have been indicted. He said that in public. It's verifiable. Isn't that true?
That is very much true.
All right, thank you.
Senator Bethel?
Thank you, Mr. Chairman. This is not a question for the witness, so if you want to hold it, I will. It's more of a legal question that I'd like to.
All right.
I'm no lawyer.
Yeah, you can be excused.
Thank you.
You want this?
Well, for the legislative council maybe, but I always, it's not fair to put her on the spot, just like everybody. I know, obviously, in a trial, jury trial, or in trial, that a witness who asserts their Fifth Amendment rights is entitled not to have a negative inference drawn against them for having asserted the right. Am I correct that that same status does not apply in grand jury? That is to say, someone testifying in front of a grand jury who asserts Fifth Amendment rights, they are absolutely protected, obviously, by the Fifth Amendment, but the grand jury is entitled to draw a negative inference from your assertion. Isn't that, I mean, am I wrong in that? Or somebody who may know, maybe?
You don't get a specific instruction in a trial. You're not going to get an instruction.
Right. So the jury is entitled not to draw a negative inference in the trial, but in a grand jury proceeding, if I say I'm going to assert my Fifth Amendment right, the grand jury can say, then you're guilty of all get out.
Correct.
No, is that what it says in here?
All right.
Is that what I read?
We'll clear this up.
I'm sorry, Mr. Chairman.
Thank you. All right, next person is Keith Higgins, attorney.
Chairman, committee members. My name is Keith Higgins. I've been an attorney in the state of Georgia since 1986. For 22 of those years, I was a prosecuting attorney in the Brunswick Judicial Circuit. I was actually working in the district attorney's office when Caroline Small was shot and killed. I'm very familiar with that case and how it was handled. Initially, I want to thank Representative Goldick for carrying this bill. It is a very important piece of legislation. It takes meaningful steps toward transparency in grand jury proceedings. It also improves the fairness and impartiality of the way in which police use of force cases are handled in this state. The bill, however, needs to do more. I'm here in support of an amendment to this to require a special prosecutor. The reason I'm supporting that and asking this committee to amend the bill to require a special prosecutor in these cases is that the issues or concerns in these cases are greater than simply transparency or actual fairness. That may puzzle some of you. The procedures also must provide confidence to the public that these cases are being handled fairly and impartially. The only way that can be done is to require a special prosecutor. District attorneys, as human beings, as elected officials, are not immune from the political pressures and considerations that come to bear on these very high-profile cases. These political pressures can be corrupting influences and result in procedures or processes that are not fair or impartial. We've seen an example of those pressures result in unfairness in the Duke lacrosse case, in which innocent college students were prosecuted for political reasons. We've seen political pressures also in the Caroline Small case result in a lack of prosecution of a case that the special agent in charge of the GBI office that investigated this case stated was one of the worst police shooting cases he had ever seen. To eliminate these problems, an amendment requiring a special prosecutor would increase public confidence in the fairness and impartiality of the proceedings. It would remove as much as humanly possible any political pressures with regard to the exercise of prosecutorial discretion as to whether or not to prosecute a case. It would also make sure that the abuses that were committed by the elected DA in the Caroline Small case would never again happen in this state. The procedures that are set forth in this bill, House Bill 941, would not prevent the improper actions that took place in the Caroline Small case. And even though that may be referred to as an outlier, it occurred and it can happen again. With regard to whether or not the requirement of a special prosecutor would impose an undue burden upon the prosecutors in this case, I disagree with Mr. Spahas. As Senator Fort pointed out, over a 6-year period from 2010 to 2015, there were 185 cases of police-involved shooting cases that resulted in death. On average, 30 cases a year. In 2015, there were 29. There are 49 elected district attorneys in this state. That is less than one case for each of those DAs to handle from outside of the district in which the police officer exercises his duties. It would not place an undue burden upon the DAs. When I was a prosecuting attorney, and during my 22-year career, it was not uncommon for our office to handle conflict cases where neighboring districts had conflicted out. I personally handled a case up in Chatham County on occasion. It did not prevent me from exercising any of my other duties.
Let me stop you. Are you advocating for a special prosecutor in just in death cases?
I would advocate for a special prosecutor in all use of force cases that result in either death or serious bodily injury as this bill defines it.
I understand that number is a lot more.
That is the only reason I don't have any figures other than the ones I gave you, because the only information that is available publicly is that which the media has divulged in their articles with regard to these number of cases when they surveyed them, and that would be with regard to deaths. I would respectfully submit, Chairman, that with regard to use of force cases, that's a broad range of cases. I would be surprised if there's 80 to 100 cases that would qualify as serious bodily injury or death. If it does, it does. But be that as it may, we're talking about cases in which a police officer has intentionally, not negligently, used force in the course of his or her official duties that have resulted in these injuries. I basically have stated everything that I wish to, Chairman. I appreciate the opportunity to testify in front of the committee.
Terry Norris. Oh, I'm sorry. Hold on a second. You passed?
No, I went after it.
All right, Senator Parent.
Thank you, Mr. Chairman. Thank you for your testimony. I'm a bit familiar with the Caroline Small case. Quick question, follow-up about that. has there been, what has happened to the district attorney in that case currently, and has that case been reopened?
Nothing has happened to the district attorney. She's qualified for re-election. She would probably run unopposed. The case has not been reopened as it stands now.
Do you think that has not penetrated with the voters in your area?
If one runs unopposed, there will not be any political consequence to that. So I don't think the electorate is an adequate check and balance in these types of cases. And I don't believe that the rules of ethics are also a effective check and balance in these types of cases, because that is always an after-the-fact consequence.
Thank you.
Next, we have Terry Norris from the Georgia Sheriff's Association.
Afternoon. Afternoon, Mr. Chairman, members of the committee. I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association. And I'm here to report that the sheriffs actually feel the current law is fair and accurate. But in the interest of openness and fairness and transparency, the sheriffs, along with the chiefs, the prosecutors, state agencies, got together to talk about ways to make the process more fair, more open. And I want to begin by thanking Chairman Golich and the co-signers of this bill for bringing it forward, because had they not done so, we probably would not be having this conversation today. I want the committee to remember one thing. Deputy sheriffs, police officers, state troopers, GAs, DNR rangers, and yes, even chiefs of police and sheriffs are the only ones that run towards gunfire. They're the only ones that go that direction. They are our protectors. They need a little bit of protection themselves. So, also under Georgia law, they're the only ones that's authorized to use deadly force. And they do so based on the facts of the situation and the training that they've had. And I can assure you that after talking to officers who have been involved in cases, no officer wants to shoot anybody at any time. Circumstances in the field are what causes these incidents. In many cases, it's non-compliance with the lawful order of police. So we applaud this bill. We think it's a step in the right direction, and we hope you will pass it favorably.
Thank you. Do we have a question? We have one last witness, Nadia Tisdale.
My name was on there, but you said you got one more, so somewhere mine's not there.
What's your name?
Jeffrey Benoit.
Okay, maybe you signed the wrong sheet. But
41.
Ms. Tisdale here. Afternoon.
Good afternoon, Mr. Chairman, committee members. My name is Nydia Tisdale. It rhymes with Lydia, but starts with the letter N. I am a citizen journalist. I video record public meetings of public interest. I have 800 videos on my YouTube channel, and my most watched YouTube video has had 62,000 views. And that was filmed at Bert's Pumpkin Farm in August of 2014 during a campaign rally to re-elect Governor Nathan Deal and to elect David Perdue to the United States Senate. During that campaign rally, while I was sitting silently holding my video camera, filming campaign speeches, I was assaulted and arrested and taken to jail and fingerprinted and put into a holding cell for simply exercising my First Amendment right to record political speech. Pardon me, it's rather traumatic talking about it. A year later, I filed an anti-blighting letter to Dawson County notifying them of my intent to file a suit. In November of 2015, I received, I found out that the grand jury in Dawson County had issued true bills against me for 3 charges: criminal trespass, obstruction of an officer, which is a felony and a misdemeanor both. So they presented true bills on 3 charges. I feel that the grand jury process is severely flawed. I was not notified of the grand jury proceeding, and the officer involved who sexually assaulted me at Bert's Pumpkin Farm and used excessive force to my body. Captain Tony Wooten with the Dawson County Sheriff's Office was able to sit during the entire grand jury proceeding and hear everyone else's testimony and also testify himself at the end. The system is terribly flawed. Yesterday, Tony Wooten qualified as a candidate for Dawson County Sheriff. That deeply concerns me. On Tuesday next week, on the Ides of March, my arraignment is scheduled in Dawson County. I am absolutely terrified, quite frankly, and when I speak about it, it brings me to tears. So thank you for this opportunity to speak. This system needs changes. You are the lawmakers. You have that authority and that ability and that right, and I beseech you, please fix this system.
Thank you. All right, and who was it that, what was your name?
Jeffrey Benoit.
All right, come on up. Thanks for that, man.
Benoit, B-E-N-O-I-T. Thank you, Mr. Chair, for allowing me to speak for this panel. I am the president of the Clayton Henry chapter of the National Action Network. There was a whole lot that I would like to have addressed this board with. I think you heard the most empowering testimony from Ms. Waiters and this young lady who just left here as to how the grand jury proceedings work. Earlier today, someone said that a law enforcement officer has to make a decision, and that decision is to decide whether or not it's his life or how he's going to produce his job or conduct his job. Let's go to South Carolina with Walter Scott. He was running away, why? Because he had child support issues, and he was shot in the back. And if it wasn't for a bystander taking a tape of that, the officer with him had already collaborated a statement to support the narrative of this officer who shot this man in the back. We've all seen that video. Let's go to Long Island, where an individual, Mr. Garner, was choked to death. And the grand jury, the DA, did what he did, and he came back to no bill. I'm fast forwarding, but we all know the story. So these are some of the fallacies in these bills. So I say to you from the community perspective, if in fact a bill like this goes forward, it is considered a vigilante bill. This is the individuals that wear the badge, has the ability to be paid from taxpayer dollars, but yet go out there and commit murder, and then have a grand jury and prosecutor and the DA, and within that infrastructure, protect them. This bill has serious flaws, egregious flaws, that does not speak to the taxpayers that hire these individuals to protect them. And I would really encourage this board to strike this down and have it reworked. And there's no problem with relaying the concrete so that we lay it perfectly, that it works for everybody. But this one here is flawed from the pouring. It is not going to work. As we have a system that is not working. I've given you the examples. The world knows the examples. We know the examples. So let's take all this into consideration as we make this very egregious and important decision.
Do you have some specific issues pertaining to this bill?
I do. For an individual to have shot someone and then sit in the grand jury proceeding to hear everything when he knows that he was the wrong. So anyway, where I'm going to this is as an individual to have the opportunity to sit in the grand jury, as we've been talking about all afternoon, in hearing all of the evidence against him, and then be able to choose not to answer after being in that grand jury proceeding, all of that is wrong. I find that to be totally wrong, that he has an opportunity to hear the evidence against him and then choose not to respond. So that's the part I want to have out there, that if he's gonna be there, he's gonna be questioned, he's gonna respond to it.
I'm not sure that's exactly the way the bill works, but we'll get some clarification on that. Thank you very much. All right, Representative Doe, are you still here?
Yes.
Would you like to make any final comments?
Thank you, Mr. Chairman, members of the committee. I'll be brief. I've heard some potential misunderstanding on the part of some people who testified today. I think there may be a misunderstanding on the part of some people that we are actually creating a right, a new right. We are not. We're actually dialing back to a certain extent a special right and privilege that police officers have to a certain extent. But we are not dialing it back all the way in recognition of the special role that law enforcement officers play in our society. We think the House is of the opinion, I believe, since it passed unanimously, I certainly am. The pitch that I would make is that this is a measured, balanced approach to a difficult issue that, first and foremost, preserves the integrity of what happens in the grand jury room, while at the same time recognizing the special role that law enforcement plays in our society. That is a difficult balance to strike, but I think we have struck it here. I know that there are there's a question or two on potential changes that I've heard. I know the special Senator Ligon had a question regarding special prosecutor that's come up in certain questions as well. The one ask that I would have on that, Mr. Chairman, is if there is going to be, and of course I'll defer to the will of the committee, the only ask that I would have from a practical, logistical standpoint is, of course, is to invest the stakeholders who would be involved in taking on those conflict cases. I don't want to blindside them. I'm sure you share that opinion as well, so that we have a coordinated approach on, well, in this situation, you're it. And I don't want any particular entity in state government to be blindsided by that. I think having them at the table would be productive on the front end.
All right.
If that's the will of the committee.
Were there any comments made that you wanted to specifically address? I just want to make sure.
I think more importantly, are there any comments that you want me to specifically address? Senator Bethel.
I want you to address Senator Bethel's.
Thank you, Mr. Chairman. Thank you, Chairman. I did have a question that I just would like your thoughts on it, really, and I know
Sure.
we're hearing only today, so we can continue the conversation.
Sure.
I was sort of struck by the suggestion that why would we make court reporting discretionary?
In the civil, thank you for the question. In the civil context, where the DA is using an existing civil grand jury as really the sounding board as to whether or not they should pursue a criminal indictment, we've mandated the presence of a court reporter in that context. So if the civil grand jury says, we've heard all the evidence, we've heard all the testimony, we don't think you should pursue a criminal indictment, that all gets taken down, it gets published, there's a roadmap and connect the dots for the people so they can know what the grand jury saw, what they didn't see, how they voted and why. That's all good. In a criminal context, if we were to mandate the court reporter in that context, I think from a cost standpoint, that would be unworkable for the local jurisdictions. As a practical matter, Senator, if you have a situation where there's a discharge of weapon by an officer and there's fatality or serious bodily injury, right now the bill says, upon request of the DA or the police officer. As a practical matter, and Mr. LaRusso can dispute this, or Mr. Spahouse can dispute it, my sense of it is the police officer is absolutely positively going to request that a reporter be in there to take down what goes on in the criminal grand jury. So as a practical matter, I think that's going to happen in those circumstances, but if we mandate it, then you're talking about a potential cost issue for all criminal situations.
Would you, and your point is well taken, maybe accurate, would you be opposed to including the grand jury as one of the entities that can request the
transcript.
Absolutely, I would have absolutely no objection to that. I think anytime you can, if that's not clear, anytime that the grand jury can be further empowered, that's a good thing. I think as a practical matter, the grand jury can tell, and there's nothing in this bill, contrary to maybe some of the commentary that's been out there a little bit, that weakens the power of the grand jury. If anything, it strengthens the power of the grand jury. The grand jury tells somebody to stand on their head, they're going to stand on their head. If there's anything the committee feels is important to augment in the bill in terms of grand jury power, that's only a good thing, as far as I'm concerned.
Senator Jones.
I just want to clear up a couple items for clarification. So right now, today, the process would be that the deputy hears the testimony and then he gives a statement. Is that basically accurate?
I'm not sure I followed you.
In the grand jury, the deputy would hear the testimony and then he's then able to give a statement.
Yeah, right now under current law, what's happened is that the officer can be in the grand jury the entire time, hear everything, see everything, give a statement at the end, and say whatever he wants to say, talk about anything. It doesn't have to be relevant to anything. He can talk about absolutely anything, and then is not subject to questioning by the prosecutor or members of the grand jury. That's correct.
And so just looking at page 6 here on line 184 to 187, so if I'm reading this correctly, he may be asked questions under this particular bill.
Yeah,
The law enforcement officer.
He will, under this bill, he retains the right to make a statement if he wants to in front of the grand jury. However, if he chooses to exercise that right to make a statement, then after his statement, he is subject to questioning, cross-examination by the prosecutor and by the members of the grand jury, and the prosecutor can also call rebuttal witnesses to potentially refute what the officer just said. Just like any other witness, just like any other individual who goes in front of the grand jury.
And that is not the current state of the law today.
Correct.
And then also, which I see, it says, after being sworn, the district attorney shall advise the officer substantially of the following. That's on 187, and it goes down to 196. And what I'm specifically looking at is paragraph number 3. So, I'm just asking for clarification. So the officer will be in front of the grand jury, he would be sworn, and then the district attorney would advise him of paragraph 3 that he may refuse to answer questions. And this would be done in front of the grand jury.
Correct.
Okay. Now, in a normal trial situation with a defendant, that would be done outside of the presence of the jury, wouldn't it? Okay. Ms. Fayos, you may chime in here, I think you may understand what I'm
I can't call a
saying.
witness in a trial just to have them vote. If they tell me ahead of time that they're going to vote, I can't call them just to have them vote.
And the reason why that would be is because we anticipate that the jury may look at that negatively. But here, this officer would be in front of the grand jury and be told, if you don't want to testify, basically you don't have to, but he's going to be giving this speech saying that if you believe the evidence would incriminate you, bring infamy, disgrace, or public contempt. And all of that would be said right in front of the grand jury.
Correct.
Okay. And so the grand jury then can make any type of summation they want from that.
Correct. They will potentially draw an inference from that.
Yes. Okay, I don't have any problems with you.
Let me just be clear on something. So, under this piece of legislation, an officer would not be able to sit in on the entirety of the grand jury proceeding.
Correct.
But he would be able to sit in, he would be able to come in and say anything he wanted to say at the end of that proceeding. Is that correct?
Correct.
And then he could refuse cross-examination. So, to protect his Fifth Amendment rights, or if he felt that he would be, and I'm not looking at the language, but that he would be discredited in the eyes of the community.
He could invoke the Fifth at that point, but I think the big difference then is, and so the question is, well then, what did you really accomplish?
Sure.
The question, the answer to that is the difference within the bill is that, you can go ahead and give a statement at the end. No, he's not been in the grand jury the whole time. He gives a statement at the end. And then he starts getting cross-examined by the prosecutor and by members of the grand jury. He decides, I'm not going to answer. I'm going to invoke my Fifth Amendment right. I'm not going to say a word. At that point, the difference in this bill is that the prosecutor can call rebuttal witnesses in order to potentially refute what it is the officer has stated in his testimony. And that's something the prosecutor cannot do right now.
I understand, but do you understand why there are some people, some of the families that I've met with, Ms. Waiters and other family members of people who have been killed in these situations, who would be skeptical of the change because it allows that police officer to go in that grand jury room, say anything they want about how they felt at the time, what they had on their mind at the time, whether, and not be subject to cross-examination. And then, do you understand why those families and the people that work with them very closely would be skeptical that this bill may not, in fact, be doing enough to protect the interests of people who are killed by officers in the manner that Ariston Waiters were?
I don't intend to stand in the shoes of those families that are affected. What I know is what the state of the law is right now, and that it is unique within the nation. What I also know is that we can arrive at something, and this building or this campus is all about the possible, right? It is the art of the possible. This bill presents a reform that is possible to pass both bodies and to get a signature that absolutely addresses directly the mechanism that provides the potential for manipulation of the grand jury process, the whole being in the room the whole time scenario, and hearing and seeing everything, and therefore tailoring one's testimony to what he has seen and just heard. But it also provides a clear recognition of the role that you heard other witnesses state on the role of law enforcement in this state. It is a balance, and I believe it is the balance that is possible for enactment.
Thank you, Mr. Chair.
I just have one question. The role of grand jury is to determine whether there is probable cause to go forward with a trial. It just seems to me in other states, I don't want to comment on Georgia, that there are many trials going on inside the grand jury in these kinds of cases. Do you care to comment on that? Like you're almost trying to establish proof or held to a standard that's higher than probable cause.
Well, I will agree with you that we've stated what the purpose of the grand jury inquiry is, but I'll also tell you this. The next step after a grand jury returning an indictment is arraignment of trial. So, from a prosecutor's standpoint, if the first time we're going to hear whatever evidence it is that's going to come from that accused officer is at trial, that forces us in a much different situation. Whereas in this situation, at least all of the evidence is vetted in front of an independent body. And that they then weigh in on that, whether it be in the criminal arena to return an indictment, or in the civil arena to make certain findings and presentments. And I submit to you that that's what we're trying to do here, is create a clean and transparent process for that to take place and for an independent body to weigh in on those facts.
All right, well, thank you very much, and
Thank you, Mr. Chairman.
it sounds like we'll be needing to talk to you further about the hospital.
Thank you, Mr. Chairman.
All right, we're going to take a 3-minute break.